Sure. Welcome committee members, liaisons, and members of the public to the Legal Services Trust Fund Commission Rules Committee meeting. Thank you for joining us. We're using Zoom with the goal to foster a more inclusive environment and effective meeting. If you would like to comment during the meeting, please use the raised hand feature. To use the raised hand feature by phone, dial *9 on your phone's dial pad to raise your hand, and do the same to lower your hand. Please utilize this tool to virtually indicate that you would like to speak in order to help the chair facilitate the discussion. Please note that all Legal Services Trust Fund Commission and committee meetings will be recorded and posted to the State Bar website. Friendly reminder that this is a video conference, and please be aware of your surroundings behind you. Zoom captioning is available. To enable, select the live transcript option at the bottom of your Zoom screen, and then select Enable Auto Transcription.
Great, thank you. Why don't we do roll call and then we'll do public comment. I know that's a little out of order, but seems to make more sense.
Great. Connolly?
Here.
Alsaroff? Fightmaster?
Here.
Blakemore? Boschelli?
Here.
Campbell?
Here.
Galkin? Meeker?
Here.
We have quorum. Let me do our liaisons. Copeland, Selena. Okay, and I don't see anybody from the Judicial Council. And the State Bar staff, we have Raul and Brady. Erica's here, I'm here. And then I'll turn it back over to you, Erica. We do have some members of the public that are in attendance, if you would like to do public comments now.
Great, why don't we do public comments? Just as a reminder, we generally will kind of leave it to about 3 minutes per comment. And if you are referencing a particular agenda item, if you could let us know that, just so that we have some context, that'd be helpful. So who do we have first?
Just one person.
Yeah, could you unmute the person?
Yes.
Hi, this is Gary Smith.
Hi there.
I want to address the recommendation with respect to fee-generating cases, if I might. I'm the Executive Director of Legal Services of Northern California, which is an IOLTA-funded organization. It covers 23 counties in Northern California. I've been the Executive Director for about 24 years. We are also funded by the Federal Legal Services Corporation, so I'm very familiar with LSC's fee-generating case rule, from which the IOLTA rule seems to have been taken many years ago. I want to speak just briefly and very narrowly to one issue in this current recommendation, which pertains to the definition of a, quote, fee-generating case. If I understand the current interpretation in this recommendation, the definition of a fee-generating case will include all cases where there is a potential, quote, fee-shifting provision involved in the underlying litigation, whereby a plaintiff who wins or prevails in the underlying case through a judgment or settlement can move for an award of fees from their opponent. Having litigated cases involving fee-shifting provisions for 30 years now, I can tell you that simply because there is a possibility of a fee award from the opponent because there's a fee-shifting provision in the underlying statute does not mean, in the language of the former LSC rule, that the case may, quote, reasonably may be expected to result in a fee from the opposing party. That's because there are very few fee-shifting statutes would automatically result in a fee award. Most fee-shifting statutes require the plaintiff or the petitioner first to establish that they prevailed under the merits of the statute, and that's a term of art, to be a prevailing party. Then, and most importantly, they have to establish that they meet some sort of substantive standard imposed by the fee provision. And then they have to show that they have to litigate the reasonableness of their hours and rates. So, for example, at page 7 in the executive summary of this recommendation, it's proposed that a case brought under the Federal Equal Access to Justice Act would be a fee-generating case because the EAJA has a fee-shifting provision. but there's no automatic entitlement to a fee under that statute. Far from it. If you sue a government entity under the EAJA, and you have to establish that you prevailed under the statute by winning or settling. But then you have to, even if you meet the definition of a prevailing party, you can only claim fees if the court finds that the government's position in the underlying case is not substantially justified. That's a very high bar. Many plaintiffs who win their case can't go on and argue that the government's position in the litigation wasn't substantially justified. Many other fee shifting statutes also require the plaintiff to meet a high substantive standard. For example, the California's Private Attorney General statute, Code of Civil Procedure 1021.5. That requires a plaintiff, before establishing the entitlement to seek fees, to demonstrate that they have, quote, enforced an important right affecting the public interest and conferred a significant benefit on the general public or a large class of persons. And there are various other requirements as well. So these are very high bars. And just because, you know, they exist sort of in theory under many of these fee shifting statutes, they're not automatic entitlements. So I don't think that just because a case arises under a statute that includes a fee shifting provision should sweep it automatically into the definition of a fee generating case. And I'm also aware of no Legal Services Corporation rule that does so either, for the purposes of its own fee shifting or fee generating case rule. So those are my remarks. Thanks.
Thank you very much. Are there, Brady, you have your hand raised? You're on mute, sorry.
I just wondered if I could ask a follow-up question of Gary.
Yes, please.
So with the LSC, you know, how do you, do they just categorically, you know, the fee shifting cases aren't under those fee shifting statutes you referenced, EJA just aren't treated as fee shifting cases?
You know, my impression, Brady, is that, and what I do is, if a case in the rare event where a case where there's a fee shifting provision that provides for an automatic entitlement to fees if you win or settle in the underlying case, I would include that as a fee generating case for LSC purposes, and then I'd go on to you know, deal with the exceptions or with other machinations that we go through with respect to LSC's fee generating case. I don't know of, like I said, I don't know of any LSC rule that, you know, deals with the fee shifting provisions of a case in any organized way. I've actually never looked at it. LSC has never, you know, asked us about it.
So, I mean, our perspective, and again, you have obviously the familiarity with what happens in practice. Looking at their documents was that, you know, these cases would be reasonably, you know, you're not going to, presumably you're not taking a case that you know is a total loser. You just like a private attorney wouldn't want to waste your time. But our thought was that the exceptions are pretty capacious, especially in terms of the exception for you know, cases of a type that attorneys in private practice in the area ordinarily do not accept. And so we after feedback from the community, you know, no longer recommend a requirement for records, but the thought there would be, hey, if you establish the criteria for the cases that you know, attorneys in private practice don't take, maybe they don't take EGA cases below this value or whatever, and then that's your criteria for imposing that. The purpose, you know, for both this and the LSC rule is, and again, this, you know, this one clarification to keep in mind is that this only speaks to how you can use our funds. It doesn't go to primary purpose or qualified expenditures. But the thought is, hey, if you're taking the LSC funds, hey, if you're taking these funds, we don't want them to go towards cases that would be taken by private attorneys without charge to their clients.
Yeah, and I think I think that's the, that's the core of what the LSC rule is all about, and I assume but again, and we undergo the same analysis that you just looked at in terms of, well, is this case that, on its face, might look like a fee generating case, is it something that a private attorney would actually take? And the answer for almost all of the cases that we do is no. And we document that in ways that the LSC fee generating case rule tells us to do, and then we go forward.
Okay,
But-
can if you don't mind, I'm gonna kind of interject here, just to, if there's other people who have public comment, I want to make sure they have an opportunity to be heard. And then, Mr. Smith, I invite you to remain on the line because this is our last agenda item. And so if you'd like to be available in case the committee has questions, we'd love for you to be available. Are there any other? Yeah, are there any other?
I'm sorry, I'm going to have to go. That's
Oh,
why.
okay.
Comment here, but I'm certainly available if anyone, you guys most of you have my contact information. I'm happy to take questions or emails or anything like that. So
Great. And we appreciate your comments. This is very helpful information for us.
Thank you.
Are there any other individuals who have public comment?
Nobody else is indicating they want to speak.
Okay. And I just to make sure we note, Selena is now in attendance, so I just wanted to make sure that was clear. Okay, without any other public comment at the moment, why don't we move to our the approval of minutes. I actually have a comment really quick before we get into it, which is my votes were not recorded on either of the motions.
Oh,
So I think I voted aye for both of them, but my name just somehow didn't end up in there.
Oh,
So I would request that be amended. And then if there are any other comments on the minutes, please feel free to let us know. Okay, hearing none. Duan, would it be should be easier to just make a motion subject to the amendment of adding?
yeah.
my
Yeah,
name?
yeah.
So I'll take any motions to approve it with the amendment that I proposed. Jim, are you going to move or Will?
I'll move. Yeah.
Okay, Jim moves.
I'll
Will,
second.
oh, okay, Vanetta will second. Okay.
I'll do roll call. Elsa Roth. Fightmaster.
Yes.
Blakemore. Bashelli.
Yes.
Campbell.
Yes.
Galkian. Meeker.
Yes.
Connolly.
Yes.
Motion passes.
Great. Okay, so now we're going to move into our discussion and action items. And the first agenda piece is something that Will wanted to present for us and a discussion piece from him. So I'll turn it over to him to let us know what it is that what are you with us about?
Hey, everyone. I am fine going second since we just had a sort of robust conversation on that second agenda item. But it's up to the commission if we want to continue since we're all now in that mental framework. I'm fine with that, but I don't know what the preference is.
Okay, that's fine. We can move to the feed generating unless there's any concerns about going out of order. I assume that's okay. Why don't we do the feed generating and then we'll take up your matter after. Okay, so I think we turn this one over to Brady and Raul.
And Raul, are you going to be sharing your own slides?
Yes.
Okay,
Give me 1 second.
I was just going to say, Raul will be leading this. I'm eating my lunch, so I will spare you.
Okay, fair enough. Thanks, Raul.
All right. Do you all see my screen?
Yes, we see.
Yes.
Okay, great. All right, so I'll get started. So I'm going to discuss proposed revisions to State Bar Rule 3.673B, governing the use of funds for fee generating casework. And so I'll start with the statutory framework. First is Business and Professions Code section 6223A. It states, and I'll paraphrase, that no funds allocated by the State Bar shall be used for the provision of legal assistance with respect to any fee generating case except in accordance with State Bar guidelines. I want to note that this restriction speaks to the use of IOLTA funds, not whether fee generating work can be counted toward a primary purpose or as a qualified expenditure. I also want to note that the rationale is to ensure that scarce IOLTA funds are not used on cases where a private attorney would be available and willing to perform the work. As part of this process, we received a concern that the rule is meant to protect private sector attorneys from competition. And I just want to clarify that that's definitely not the case. The Business and Professions Code also defines what is a fee generating case. In section 6213E, it states that a fee generating case means a case or matter that, if undertaken on behalf of a diligent person by an attorney in private practice, reasonably may be expected to result in a payment of a fee for legal services from an award to a client from public funds or from the opposing party. So section 6213E also provides for various exemptions from what counts as a fee generating case. I want to try to actually go through these and paraphrase them a bit, just because I think they're relevant to our discussion later on. So the first exemption is for if the recipient determines that a free referral is not possible because of any of the following reasons. A, that the case has been rejected by a local lawyer referral service, or if no such service by two attorneys in private practice has experienced the type of case. B, that neither the referral service nor an attorney will consider the case without payment of a consultation fee. C, that the case is the type that attorneys in private practice in the area do not ordinarily accept or do not accept without prepayment of a fee. And D, that emergency circumstances compel immediate action before a referral can be made. The other three exemptions are for when recovery of damages is not the principal object of the case, where the court has appointed a recipient or employee of a recipient pursuant to a statute or court rule, and 4, that the case involves the right to a claimant under a public supported benefit program for which entitlement to benefit is based on need. The relevant State Bar rule concerning fee generating cases is Rule 3.673B. I won't read this to you, but two important things to note. It requires that recipients maintain records reflecting the facts that led to a conclusion that a case fits under one of the exemptions. And it also requires that any fees generated from a fee generating case only be used, quote, for purposes permitted by statute. So I guess what are the existing concerns based on the current rule? Based on the existing statute and rules, staff experience and feedback we got in this process, there's a few things that came up. First is that there is some confusion, I think, as to what counts as a fee generating case. It also came to light that the State Bar has little to no window into how grantees are actually invoking particular exemptions. Although they're required to document the facts leading to the termination of an exemption, they're not required to submit those records to the State Bar. And in practice, the invocation of exemptions has not been a focus for State Bar staff. And finally, that the rule that recovery of fees in fee generating cases may only be used as permitted by statute is perhaps not as clear as it could be. Okay, so considering how to approach a potential revision to the fee generating case rule, it was useful to look to the federal analog in the Legal Services Corporation Act and its regulations. The federal regulation also contains a definition for fee generating cases with a similar prohibition of the use of such funds in such cases and exemptions that parallel those that apply for the State Bar. I'll just note that the State Bar rules are almost certainly borrowed from the LSC regulations, as the original definition in the federal regulation is identical to that of the State Bars. However, in 2017, LSC's regulation was revised And I have here the 2017 version up top and the current state bar definition to illustrate the difference. And if you'll see, the main difference is the missing language in red, which in the state bar says that includes cases for where a fee is from legal services from an award from public funds or from the opposing party. When the LSC changed their regulation, they stated that it was to make sure that the language an award was not read to only modify to a client, but should have modified also from public fund and from opposing party. This means that the issue with fee generating cases is not that it receives funds from public funds, but if it results from an award from public funds. In other words, funds obtained in suits against the government. So we wanted to discuss an example of where the lack of clarity of the definition of fee generating case came up in the past. In 2019, the Legal Services Trust Fund Commission discussed the application of a grantee that was receiving partial funding from a judicial entity to provide services to indigent parents and children in a juvenile dependency system. Out of concern that the funds were from public funds and would run afoul of the rule, the Legal Services Trust Fund Commission recommended that funds not be budgeted in cases where the grantee had an existing funding contract. However, this should not have been an issue because the source of funds in this case would not have come from an award of public funds. I also want to discuss just a couple examples of where recent examples where invocation of the fee generating case exemptions have come up. So in 2022, the State Bar learned that about half of a grantee's revenue was derived from attorney's fees available in special education related cases. The grantee staff had expressed to State Bar that recovery of attorney's fees in those cases was a significant focus for them, and it influenced the decision on whether to provide representation in individual cases. Ultimately, the decision on how to handle that was deferred until after codification. However, I do want to note, although whether recovery of significant attorney's fees is a focus in a case is one of the available exemptions, and so in this case, they would likely not be eligible for it. It's 6213E2. That does not mean that these cases would not fit within another exemption. For example, that this type of case that private attorneys would not ordinarily take. And for the third example, this is sort of just a classic example of how this probably works. In 2022, a grantee expressed concerns that they were handling fee generating cases. Those cases involve representation of elder abuse clients where mandatory attorney fees are available. In that case, the State Bar determined that since the grantee represented to us that private attorneys would not typically assume the type of representation, and also that the recovery of attorney's fees was not the main purpose for taking on the representation, that this type of work was exempt under Business and Professions Code section 6213E1C and E2. So we prepared an initial proposal and shared it with the Legal Aid Association of California. Based on their feedback, main concerns were that the definition of fee generating was too broad. For example, that it would capture fee shifting statutes. Although fee shifting statutes necessarily, I think, fall within the definition. Whether there's a determination that it may reasonably be expected to result in such awards in one case versus another, it's not something that we've addressed here. I will also note that our proposed revision to the definition is not intended to substantively change the scope of what counts as a fee generating case, merely to clarify the definition. The other concern, so we initially proposed that grantees be required to submit the records that they are required to maintain under the present version of Rule 3.673B. However, the feedback we received is that this would create significant administrative burden on grantees. So accordingly, and based on based on that feedback and staff consideration of the options, our proposal is now threefold. One is to go ahead and clarify the definition of fee generating case to match the federal analog to ensure it only applies to funds from, quote, an award. To avoid the burdensome documentation requirements, that we instead ask grantees to self-certify that any fee generating case is exempt. And finally, to clarify the rule to ensure that the recovery of attorney's fees are only used to provide services to the indigent. So here I have the sort of mock-up language of the revision to Rule 3.673. There's three main parts. One, the crossing out in red of purposes permitted by statute and adding, quote, civil legal services to the indigent in California. That's just to clarify that the recovery of attorney's fees in any of these fee generating cases are only used for such purposes. Second, it imposes the certification requirement by adding language that says recipients must certify with their annual IOTA/EAF application that any fee generating case that received funds is exempt. And finally, in adding section C, it adopts the federal analog definition of what is a fee generating case. So although this isn't addressed in our proposed revision to Rule 3.673, I did want to tee up for discussion how State Bar staff should consider implementing the self-certification requirement if that's indeed adopted. As a reminder, Rule 3.673 requires that if a recipient determines that a case is not fee generating because it qualifies for a statutory exemption, the recipient must maintain records reflecting the facts that led to that conclusion and any action taken to confirm it. But the question remains whether we should allow grantees to do a blanket certification by the types of cases they handle, or require certification on a case-by-case basis. How to self-certify and what records they're required to maintain likely depend on the type of exemption that is invoked. So for example, E1A, E1B, and E3, that's the exemption for where it's been rejected by a referral service or to private attorneys, that an attorney will not consider it without a consultation fee or involves a court-appointed recipient. That type of exemption may simply require maintenance of emails and other documentation. Exemption E1C involving a sort of statement that private practice attorneys do not normally accept that type of case, may require establishing criteria defining what types of cases are not normally accepted by attorneys in the area. Oh, sorry. E1D is about is the exemption for emergency circumstances. Again, there may be some documentation about those circumstances. And then exemptions E2 and E4. So E2 is where recovery of attorney's fees is not the principal object of the case. And E4 is where a claim is under a publicly supported benefit program based on need. Those could likely be documented simply by maintaining the pleadings indicating the case type. So just again, for reference here are the exemptions. Okay, and then, so based on that, the summary of our recommendations as follows: that we adopt the proposed language from the federal analog to the definition of fee generating to ensure it only applies fees generated from award, that we impose a self-certification requirement on grantees with an additional focus by State Bar staff on how those exemptions are invoked, and finally clarify that only that fees recovered in such cases may only be used for the provision of services to the indigent in California. And so if the committee approves the language I have here for the proposal is as follows: that the Rules Committee of the Legal Services Trust Fund Commission approves the proposed modification to the State Bar Rule 3.673 as discussed and recorded at the meeting on April 27th, 2023. And if we want to make any revisions to the actual wording, I can also pull up that language for revision and discussion.
Great. Thanks, Raul. Jim, you have your hand raised?
Yeah, I got a couple questions. Is there any definition about what is reasonably may be expected to generate a fee? Because what I gathered from Gary's discussion comments earlier is that there are a lot of these cases that you can win, but not necessarily generate a fee. So what does reasonably mean? 50% of the cases, 90% of the cases, 10% of the cases? Because it sounds to me, some of these cases, the way Gary Smith was presenting it, you're not always going to get the fee. That's one question. The second question is where it said the fees could only be used permitted by statute. You're getting rid of that and saying civil legal services, but did the statute ever define what other uses could be done or used with the fees? And then finally, I got a little confused. It seemed like fee generating and fee shifting were being used interchangeably. And I don't understand what a fee shifting situation is.
Yeah, so see if I can address those in turn. So the definition of like reasonably may be expected wasn't something that was focused for us when we were looking into this. I will say, you know, we consider with the exemptions that the grantees consider that they'd be required to self-certify. So I imagine that's something we can consider developing criteria about why something where an award is available would not reasonably be expected to result in an award. But I don't have a proposal for that at the moment.
Let me jump in. What I was hearing from Gary is not actually, I wasn't actually hearing an issue with this or any real conflict with LSC because, I mean, by nature, the whole point of these fee shifting cases, and I'll address that question also, is that, you know, you take them if they're meritorious, which again, you're taking them because you think you have a reasonable chance of winning, you'll get fees. The giant hole in that, which is totally consistent with the purposes of this, is if you can say, you know, oh, for these reasons, and you don't, you know, our thought was that you'd basically, you know, the attorneys in your area, you as a grantee, so you're going to say these are the types of cases that, you know, fee shifting cases that attorneys in this area just don't take, and then that satisfies the exemption. You know, the language both from the LSC regulation, which we're now matching, is pretty clear that it is the whole point of the regulation is to get these fee shifting cases. Now, a fee generating case, that's just the words from the IOLTA statute and the LSC regulations. Fee shifting is any case where if you win, you know, you're entitled to attorney's fees. They're the exception to the American rule where each side pays its own. So I'd wish Gary had stayed on because I didn't really see.
I think he might still be on. I think just saw his hand raised like a minute ago.
I mean, I think that our focus just conceptually is on this. Hey, here's the universe of cases that this is that this rule is targeting, which is cases where you can reasonably expect to get an award, and that's why private practice people would take these kind of cases because they can reasonably expect to get a fee award. But there's other exceptions. But if this is the type of case that private attorneys in your area won't take, you know, then it's an exception. And I wasn't hearing necessarily that this is different than what's happening with LSC.
Thanks, Brady. Dwan?
Yeah, I just gotta just so that we're all on the same page. I think what I'm hearing Brady and Raul suggest, and that's in the memo, is that to kind of address Gary's concern about, you know, in some of these provisions, there's not an automatic kind of attorney's fees in these instances, but they can still evoke the exemption if they just have an internal policy. So it's like one additional step that I don't think LSC is whether LSC programs are doing it or they're enforcing it, but we're adding one additional step then. Is that right then? I mean, it still gets at the same end goal, right? So those cases that Gary was talking about, we're not outright stating they're not fee generating, but we can say that you still qualify for an exemption if you have a policy that states for these cases, private attorneys in private practice won't be able to take them because X, Y, and Z. So am I summarizing it right?
Yeah, and I think I wasn't actually hearing what LSC was doing, because again, they define it the same, and we didn't find a contrary definition. It sounds like there isn't one, so maybe it was. I'm not sure how that reporting works,
Yeah.
but this seemed like a relatively low burden, because again, you're gonna set the criteria, and then hey, if the cases meet it, you self-certify. But that at least asks programs to think about, hey, is this a case where private attorneys in this area would take it because of that expectation of fees? And if it is, they should try to get it. If it doesn't meet the criteria, then there's another exception that if that person goes out and can't get the lawyer referral service, refuses it, or I think do I have it? To private attorneys in private practice. So I mean, it's sort of a double check, because the organization under exemption C in the statute would have a policy that says, hey, based on our experience of our knowledge of the market, these fee shifting cases, either by size or nature or whatever, private practices aren't going to take it. If a case that comes into intake at one of these grantees doesn't fall into that, and the grantee goes out to try and find private attorneys and then can't, there's another exception that says, hey, they can come back. I talked to two private attorneys, they won't take this case, and then that's another exception. So it sort of acts as a pretty simple, not a lot of burden now that we're not requiring them to submit the paperwork. Check on, hey, are you spending our money on something that there are private attorneys who would do free of charge to you?
I also want to add that these exemptions are alternative. In the context of fee shifting cases, we've been talking about whether other attorneys would take it. But there's also the exemption where recovery of damage is not the principal object of the case, which could also be a basis for exemption, particularly if they think recovering fee shifting cases is incredibly unlikely.
I was going to say, so I guess the question is it, because this isn't sort of stated very clearly in the rule, but is it your view that any cases brought under a fee shifting statute are per se fee generating, or is there an opportunity for them to provide evidence that actually, given the high burden, almost no one gets their fees shifted, ergo we think in this category of cases it's very unlikely to be fee generating, and ergo it's not a fee generating case?
Yeah, I mean, I don't think there's anything in the rule that forecloses that. I think conceptually, we were, thinking of these fee shifting statutes. That's the whole point for most of them that I'm aware of. If you're bringing a meritorious case, you reasonably expect that you're going to get fees. I think it might be a little bit. I think the answer to your question is yes. I also think that, again, this involves them with their knowledge having some sort of policy. And I think that the result is probably the same either way, because if there are cases like that where they're not going to get fees, then no lawyer is going to give them, going to take their case for free.
They may be able to qualify for multiple. I'm just curious, how stringent we want to be on defining fee generating versus fee shifting. And I was just thinking about Mr. Smith's point about, if the government doesn't have, there's fee shifting only when the government doesn't have substantial justification, right? That's not a that's not a low bar, right? At
Right.
times. So you could potentially see a situation where the government, most of the time there's not fee shifting, even if it's a possibility.
Right, right.
I just want to add that in the rule, the record maintenance requirement applies to invocation of the exemptions. So if it wasn't sort of per se, and then later they recovered attorney's fees, then the way the rule is written now wouldn't have the documentation requirements. So you'd want to bring it within the scope of fee generating cases and then require the exemption to be invoked. So we're ensured that any attorney's fees recovered are tracked and only used as we require in the rule.
And I mean, and maybe it would make sense to for consideration, are there, again, it's not in the rule, and I don't know that it should be, but if we could find out, if there are, whole categories of fee shifting type cases where it just isn't reasonably expected that, even if it's you think it's a meritorious case, you're not going to get fees, and then I think that would fall out of the definition, based on our limited look at most of the fee shifting statutes we heard of. They seem to be falling within that definition.
Okay. Will, and then Dwan.
Yeah, I just want to confirm my understanding. So we have the 4 exceptions, one of which is 4 statutory exceptions, one of which has 4 subcategories. We can't change those. Those are the way it is. This rule is not necessarily expanding, but could be interpreted as expanding the exceptions by saying a fee generating case means any case or matter which reasonably may be expected to result in a fee. And if it's unreasonable, if we're saying that, oh, we don't usually get attorney's fees on these sorts of cases, then it doesn't count as a fee generating case. And so we're actually expanding the allowable exception here to take that into account, is my interpretation.
I think that part actually existed. I think in this discussion, we're sort of clarifying that, yes, that would be a, that is another way that cases wouldn't fall under this. I thought you were going to go with the way that the statute's actually written, and I think that one of the key clarifications here is, and I'm looking at your. Ma'am, can you pull up the statute language, Raul?
Yeah.
It's piggybacking on this change that the LSC made, which is, and this is the change made through the new subsection C for Rule 3.673. That fee generating case means a case or matter that, if undertaken on behalf of an indigent person by an attorney in private practice, reasonably may be expected to result in a payment of a fee for legal services from an award to a client, comma, from public funds, comma, or from the opposing party. Previously, we had concerns, and we understood that to mean that that any payment from public funds fell under this rule, and that covered things like providers who are under contract with counties to provide conservatorship services to the indigent. LSC interpreted the same language as saying, no, award actually is modified by client, public funds, and opposing party. So it's an award from public funds, an award from the opposing party, an award to a client, which all actually falls into an award to a client. So this actually is less restrictive than we had previously interpreted the statute in that respect.
Go ahead, Dawn.
I was gonna say, following to Brady's previous comment, so if the committee is agreeable to this general framework, but we want to do a little bit more kind of investigation to see if there are categories of cases where it's not going to reasonably lead to kind of a collection of attorney's fees, then maybe we can work with Selena to get those categories of cases from programs. And then in the next iteration, I would not suggest to roll it back to the rules committee, because if you guys are generally okay with the framework, then in the next memo to the commission, we would write that into the memo. I don't think you need to codify that in terms of a state bar rule, because you know, it could be a long list. You don't want it to think that it's only exclusive of that, but I think maybe building it into the memo itself, some additional guidance, and then that will have that, and the staff will know to give TA to programs that, hey, these are the categories that, you know, like it's already been pretty much pre-approved that you know, it applies or doesn't apply.
Thanks, Dawn.
And
Jim?
then Erica, there's a member of the public that has their hand up.
Okay, let me get Jim, and then if we could, we'll take the public question.
Just a question or clarification on the fees have to be used for legal services for the indigent in California. Does that mean you actually have to document what case you used it on, or does it go back to the general legal services provider's budget, which could cover attorney salaries or paralegals or operating funds? I mean, how restrictive is that?
I can take that one, Brady Roll, because it's part of our monitoring visit. So when we go on monitoring visits, our fiscal team makes sure that there's, like, you know, the funds are separately, and if there's attorney fees that come back, then they roll back into the delivery of legal services for the indigent. So there is a way that our fiscal team kind of tests for that.
Yeah, this is just a clarifying change, not a substantive change.
Okay, so like going to their attorney salaries or paralegal salaries, that would count, right?
Oh yeah, that would count. Yeah, yeah.
Okay.
I think we actually, Raul, if you've got the document open, I think we need to add free civil legal services to the indigent. Free.
Yeah. But salaries do count as long as the staff is working on delivering free legal services. Yes.
Okay. So I see Will, but do we still have a member of the public?
We do have a
to
member of the
comment?
public.
Will, do you mind if we let that person go?
Please take them first, yes.
Kim, can you unmute the person?
Hi, I think can you hear me okay?
Yes, yes.
Yeah,
yes.
we can hear you.
Okay, great. So I have a question about exception 2. Recovery of damages is not the principal object of the case. And I'm curious about whether there'll be any guidance, not codification, but just even guidance on how that will be viewed by the bar. Because I could see that being pretty subjective. And I'm thinking about an instance, as we know from the onset of a case, we really don't know if we'll get damages, and if we do, how much they will be. And I'm thinking of, just for example, a case where we're representing a client and we want to keep them from being evicted, staying in their home, but they may, as a consequence at the end of the case, receive, a substantive damage award. And so I'm wondering how that will be viewed by the bar.
Yeah, actually, before we comment, do you mind introducing yourself?
Oh, sure. I'm sorry. I'm Lori Furstenfeld, and I'm Director of Legal Advocacy at the Child Care Law Center, and we are a support center.
Okay, just wanted, if you were willing, I just wanted to make sure we understood.
Yeah.
Okay, does anybody, Brady Roll, do you have any comments on Ms. Furstenfeld's question?
And I could take a stab, Raul and Brady. You let me know if you would be okay with this. OGC would be okay with this. I think it's a fairly, like, if it was state bar staff in our office, it's a pretty low bar. I think a lot of the cases that you all take as a legal aid agency would fall under that. A desire to help the client, desire to help low-income communities, right?
It's about what the particular case is asking for. So here it's asking to, order them not to be evicted. So that sounds like it's about what relief is being asked for. But again, I think that what you're saying is generally correct in that it is it's a matter for you to care if you can, in good faith and reasonably characterize it. The primary aim as non-pecuniary relief. You know, the order to not be evicted. That justifies it under the terms as far as I see it.
I may have a follow-up question on that point, but I'll let Selena go first.
Mine is just, I think like once this goes out to programs, after the rules revision process is complete, I think it would really help to make it clear, given all of the turnover we have with executive directors and directors of litigation, making it clear what the Trust Fund Commission determines as fee generating based on that reasonableness factor, to go back to what Jim said earlier, and then what is fee generating but would be eligible for one of the exemptions. Because I think that's the piece that a lot of organizations will be like, is it fee generating or not? What do I need to do? And it could be fee generating, but under one of the very broad exceptions where, like in Gary's region, he knows a lot of, there aren't enough private attorneys to take the case, and they do the work to say it's actually exempt, even though it's fee generating. So it's like, is it fee generating, yes or no? And then even if it's fee generating, having organizations be really clear on what is needed for to show they did the work for the exceptions. And just one really quick comment. I did talk with one organization that they do all of this work and they do the analysis of whether to take what could be a fee generating case. And it's in these very long memos. And so they don't have like a click the box to say, yes, this is fee generating. Here's exemption number, E4. And so for some organizations, they're doing the important work, but they don't have an easy way to show it. But that could come up in like discussions at monitoring visits.
So I mean, I think, and we'll want more follow-up from you on what the community views is not reasonably expected to find a fee. I think that on the exceptions, though, our thought was that the way to do it is, they know their cases. So if they establish, criteria, and if we ask about it in the monitoring visit, and they say, this is our view in our market, and if it's reasonable and good faith, that's I think what we're looking for and what the intent of it is. And I think for the self-certification to take that, I think it'll just be a box in the application, So if they've done those memos, that's great. And if in a monitoring visit, if we have a question, we can ask. But it would be a sort of a click the box.
So Dawn, do you mind if I ask my question, because it's kind of related to this, and then I will let you go. One thing, the second exception, and I think Ms. Furstenfeld's question kind of triggered something for me. There's no preclusion, right, for any of the LSOs to seek damages on behalf of their clients, correct? Even if they just have to not take any of the money, right? And so,
well, yeah, that would be that would be not free legal services, right?
Yes, but so I understand this is a statute, but like I don't totally understand exception 2 then, because so basically you're allowed to have a contingency fee or recovery of fees if it's not the principal point. Is that kind of what the point of exception 2 is?
No, I think it's talking about like statutory. Like if the case is just for injunctive relief, then it's an exception. Can you say the question again?
So if it seems to me, and this is maybe just I'm misunderstanding the point of exception 2, but recovery of damages is obviously not the same as recovery of fees, right? And so I guess what I'm a little bit confused about is in a situation where you move for injunctive relief and you wanted recovery of damages, like, is it that you can move for injunctive relief and if there's some damages and you get paid, that's okay?
Well, no, it's that. So first of all, this doesn't even come into play if there's not something in the cause of action that's going to give you attorney's fees, right?
Right.
and often those are percentages, or sometimes they're hourlies or whatever. But this is for whatever reason saying, hey, we're really concerned here with the with the damages suits that are fee shifting. And so this is saying, hey, even if there's reasonably expected to be a suit for or fee shifting available, if your suit's really aimed at injunctive relief, not damages, then we don't count it. I actually don't really understand the reason for that exception myself, and there's nothing in the legislative history about it. I don't know, Raul, I didn't look, a lot of this is borrowed from LSE. Might be interesting in the next go round if there's some basis in the LSE statute for why they did that. But
it's just a weird exception, because it seems like
what should matter is
like limited to fee shifting, and it
Right.
just sounds like a weird, like, you can, as long as you're not like that, somehow you could still get a contingency fee as long as it's not the main purpose. I know that's not what you're interpreting it as, but it reads a little bit like that. That's all. Anyway, that's just a side note. Dwan, sorry.
I was going to say, the follow-up to Selena's request about kind of guidance after it's codified, can I actually ask that maybe Raul and Brady put together a chart or something, that guidance, so we're all really clear about it in the next go around to the commission? Because this topic was, we asked OGC to do it because I don't think any of our staff have the expertise in terms, I mean, it's very technical, it's very steeped in like being, the practice of, and so if that's, I think if you guys can develop a chart in terms of categories of cases, how would be practically, and the program staff can help. But the thing is, like, I don't think the program staff have like the substantive knowledge to kind of develop that. You guys have to be okay with it. That's what I'm saying.
I think the first thing will be for Raul to reach out to Selena and say, hey, what fee shifting cases, in other words, what cases where you have the potential for getting an award if you prevail of attorney's fees, do you view as in general not reasonably, where you don't reasonably expect to get a fee, and for what reason, and then if we could get some feedback on that, and just a short explanation why they think that in the cases that they take under that statute they don't reasonably expect it, then we can review that.
And then one other question is that I'm going to anticipate from programs is if they draft a policy, I think the programs are going to want guidance and like what's sufficient in terms of a policy. Like we say reasonable, but I think they need to like have some. I mean, programs want to do the right job. We have to guide them. So if there's something that the two of you I think is like a reasonable standard for that would help. And then the program staff can kind of work up some of the practical kind of, I think that we're going to get that question. I'm just sure of it.
Great. Thanks, Dawn. Selena?
Well, I was actually wondering if anyone had public comment, because I asked a couple others who practice other areas of law to see if they could join. I haven't practiced in 15 years and I couldn't remember a lot of this. And so I didn't know if there are other members from our community who may be able to, who've joined and may be able to answer some of these questions.
And there's a hand raised. So if we want to take.
Sure. What?
Hi, it's Gary Smith again from Legal of Northern California. I just wanted to clarify, there's a misunderstanding about how the LSC rule actually works. And the cases that are quoted in the statute, those are sort of the universe of cases that, from which a fee generating case might arise, right? But LSC doesn't have any blanket. It doesn't say, well, fee shifting cases are all fee generating or any of those others. It's up to each program to determine in each case whether or not it is a fee generating case. That's how we do it for LSC purposes. And the factors how we determine that are the factors, that are in the rule. but we make that determination. And if we determine before we file a case that it is a fee generating case, then, and if we want to take it, we will go through the exceptions that are in the rule. But I make that determination. And there are many times, even though the case is technically or theoretically a fee shifting case, for the reasons I outlined earlier, I make the determination that it will not reasonably be expected to result in a fee for a private attorney. So it's not a fee generating case. That's how the LSC rule works. And if I determine, because it's a fee shifting case or for some other reason that's in the rule, that it is a fee generating case, then I'll go through, and we want to take it, then I'll go through the exceptions that are in the rule. So that's just a clarification. LSC, we interpret LSC's rule to just sort of lay out the universe of cases in which there may be a fee generating case, but it's up to the program to make that determination. And there's not an automatic determination, a threshold determination by LSC that all of these cases are necessarily fee generating cases. That's not how it works.
Mr.
That's go ahead.
I just had a quick question. Does LSC, when you say, you sort of make the determination up front, does LSC have like factors that look to that, or is it just this reasonable expectation language?
It's our call, and if LSC monitors us and they look at a case, they can say, well, why did you determine that this was or wasn't a fee generating case? And we have backup and documentation in our case file as to whether it is a fee generating case, why I made a determination that it is or isn't, and if it is, how we fit into one of the exemptions if we decided to go forward with it.
Sorry, I think that's very helpful. I think I'm asking a slightly different question, which is there any additional like regulations or like guidance that says these are the types of, this is what would qualify as a fee generating case?
Not that I know of. And,
Okay.
LSC comes up with all sorts of weird sub-regulatory stuff, and sometimes I see it and sometimes I don't, but I'm not aware of it, and LSC has never asked me about it or cited to it.
Okay, that's helpful. I just wanted to get a sense. Anyway, go ahead, Brady.
No, it's just, I mean, I think we're largely on the same page conceptually, and the sort of the rule we've written still is consistent with that. I think it probably wasn't communicated. It was asked, does this cover these? And I think we probably shouldn't have said yes, but we should have said, yes, unless it's not reasonably expected that, that there would be a fee in a particular case.
Yeah,
but they're certainly within the universe of cases that this rule, both LSC and this one, wants you to go through the analysis for.
Yes.
Is there any other members of the public?
No one else has their hand raised.
Okay.
So can I just make one? I mean, there's a sort of a sort of hearing two different things. One is that we want clear guidelines, and here's the rules, and here's what counts and what doesn't, versus more of a here's a worksheet. If we ask you, can you certify that this happened? And if we ask you about it, can you justify your determination? And I think those are sort of two different approaches. And it sounds like LSC, it's more the latter, that for these types of cases, each program makes a determination and keeps backup for it.
That's correct.
Okay. Other questions or comments? Oh, Selena.
Oh, just reflecting on what Brady just said, it seems that also it would depend on the sophistication of the program, which one they felt more ready to follow. I think that Gary's program and many others feel very confident in their ability to do this determination for everyone. But I would expect some of the newest and smallest IELTS funded programs may want a little bit more guidance. But yeah, I think that those would definitely feel like two different approaches.
I mean, it seems to me like maybe the right approach is a sort of fairly broad rule as it's sort of drafted. And then, I mean, I sort of think we should have like an online library because we have all these things that we keep in memo form and we keep saying we'll use that, and you got to go like figure out which meeting it was at. So it might be useful at some point to have like kind of a library of guidance, but it might be useful to have the chart as a reference point for kind of staff and for the organizations, just so that everyone sort of knows the table setting. I don't know, Brady, Raul, does that sound like something that's feasible?
Or, I mean, maybe the more simplistic, and this could even go into the rule that, statute, cases brought under statutes that provide for a fee to the prevailing party are considered fee shifting unless the grantee makes a determination that that fees aren't reasonably, that there's no reasonable expectation of fees in this case for attorneys in private practice, something like that. So it's it's simpler for the programs that don't want to go through the analysis. Hey, for these cases, I just need to make sure that there's one of these exceptions apply, or for programs that are comfortable with the analysis to say, hey, we've looked at this case and we don't think it's reasonable, but we're still taking it.
So on this point, I actually have two follow-up questions. One is somewhat similar to what you're saying, some clarification on burden, and also like this may be in a different rule. Sorry if I'm expanding us, but like what happens if there's a finding that they took money or they used our money on a fee shifting case? Like what's the process, right? So let's say there's a monitoring visit, staff says, yeah, we disagree with you. We think this was, a fee generating case and you don't meet any of the exceptions, or you don't have documentation. Then what happens? Is it that without documentation, you automatically lose, and, or without sufficient documentation, is there an appeal to the commission? Is this all laid out somewhere else? Yeah, Dawn, sorry.
Okay, so I think that laid out somewhere else is the topic that you're working on, Erica, in terms of, never mind, you're not meeting yet. On Friday, when you meet with your working group about there's a proposal for your working group around fiscal stuff that's related to monitoring visit findings and what will trigger commission approval. So this is where that would go in terms of findings.
Okay, I guess I'll get really familiar with it tomorrow. Okay, so that's the idea. Is it would all be sort of fiscal monitoring. That's the bucket that it would go into.
Well,
right?
Fiscal and program monitoring, but it would go under monitoring. Well, and the thing is, I don't want to limit ourselves to just monitoring. There are occasional that we, the commission, the trust fund program finds out that program did something we require a little bit more. So it's not just monitoring. I would say, and our grant provisions provide this, programs have to keep documentation consistent. If we want to, question them outside of monitoring visit, which doesn't happen often, but it does happen, that we, the commission has a right to, and the state bar staff have a right to kind of email and request that at any given time.
Yeah, I mean, I think it's a little bit, and maybe this will be addressed in your working group, but there's a, just a degree of sort of discretion in how things are applied. I mean, we don't want to be clawing back money from anybody, and that's that's happened. I don't even think in that case I'm thinking about, we clawed back. We just we found that they were not eligible and reduced their future grants, but that was for serious willful violations. So it's really more of a generally more of a monitoring and guidance issue. Like, hey, either you're not showing that these cases follow this definition, or hey, it looks like some of these cases maybe you shouldn't be taking. So
but it's fact specific, right?
Yeah.
So if there's an organization that was taking attorney's fees and doing something really inappropriate, I mean, it's gonna rise to the commission much sooner, and I'm assuming you guys take the more serious action.
Okay. Sounds good. Thank you. Will?
This has been incredibly helpful for understanding section E here. I didn't realize it was lifted directly from the statute, that last part. So I agree with Brady that clarifying language that you can either get the 4 exceptions, that's just a checkbox, or you can conduct the analysis that it would be unreasonable to expect this to actually generate fees. I think that would provide a lot of clarity for programs, and then they can pick their poison, so to speak. You know, I just want to check off the exception, or I want to conduct an analysis. I think that's helpful. And then to Raul's earlier question about whether it should just be a bulk check or they need to keep track of individual cases. I mean, I think given the statutory specificity here, they should keep track. We should be able to pull the records on each case when they've made that determination, because it's either a checkbox or they've already done the analysis either for themselves or for LSC. I think that's reasonable.
But I think we don't,
to-
we don't want,
Oh.
I mean, but you're not saying like, and I think that's sort of, we would just have them in their certification to us though, not go through every case, right? But
I don't think that would be necessary, but it should be something at a site visit they can easily
Right.
pull up, that be available and that they know that they have to keep those records.
But are you
Yeah,
saying,
I don't think we have to.
is
go ahead.
it for each case though? What if there's like a policy for like a grouping of cases? We're fine with that, right? We're not asking for each. They'll have some tracking mechanism. I'm hoping that if we do happen to pull something, that they can track back to whatever exemption it is.
Yeah, someone at some point has to make a determination that it's either one of these exceptions or it's unreasonable to expect that this case would be fee generating. And keeping track of that shouldn't be too difficult, I presume. Maybe that's an unreasonable expectation.
and maybe we could, I mean, maybe we could even have a template checklist that, you know, we could have, not required to use, but that we could, you know, make available or in conjunction with Selena, make available. That would be just something you could, if you want to follow that,
Oh, yeah.
just put it in your case file.
I love checklists and making it as easy as possible. If we could generate something like that, I think it would be very helpful for the community. So yeah, and Duana, I think I'm comfortable with the framework. To answer your long ago question.
Yeah, I tend to think if there's a policy, like, for example, if there's some stats that attorneys in the community don't take, you know, disability recovery cases, and you determine it's a disability recovery case, that's the extent of it, right? Like, we don't need them to like do anything more burdensome than that, is what I assume, right? So it's a little mix, right? You have to make sure it falls into the bucket, but once it's in the bucket, it's good. So at this point, should we, what's the best path forward? We want to get this prepared to go up to the commission. Is there other stuff we need to do? Brady?
I mean, I could see, depending on what we hear back from the community, either making some additions to the rule or not, and just putting memos in. And if it's, I think we're sort of agreed on what the intent here is. It's just a matter of doing it. So I think it could go straight to the commission, or it could come back here.
I mean, it makes sense to me as long as there's not, my only, I guess, caveat would be unless there's something wildly different that occurs that might be worth us vetting first. But it seems to me like I'm comfortable with it going to the commission, you know, with the tweaks that we're kind of discussing. Anybody else have a differing view? I don't want to. No, I'm not hearing anyone. Okay. So I guess at this point, do we need to make a motion, or can we just kind of?
Could you vote? Because then at least when we take it to the commission, we can say that,
Sure.
you know, you voted and then this is what happened afterwards. And this is the addition to the memo.
Yeah.
Okay. How do we want to phrase that though?
I mean, maybe it could be to approve it with, you know, with potential modifications or sub-rule guidance to be included in the presentation to the commission. based on further communications or further, discussions with the community.
That works for me. You
Rahul,
guys
could
don't
you,
mind?
yeah, Rahul, could you mock up your motion and just include what Brady said, and then maybe you can show it with everyone before we.
That would be great.
Yeah, while he's working on that, is it fair to say that this is just to protect private practices? Like the legislature included this rule because they wanted to protect private practice.
I maybe it's a different way of I'm usually pretty cynical, but I think it's because if there are private practice attorneys who will do this, why should we be using our money for this rather than other cases for the indigent that private practice won't do? You know what I'm saying?
Yeah, that's how I would
Okay.
look at it too.
There's
In
a,
a more,
there's a,
more
there's
positive.
a lot of
Yeah.
money, and why that if people can get free services, from private attorneys and get their fees paid for by the other side.
And I'm usually more cynical because LSC used to restrict any attorney's fees awards to any of its LSC recipients. So I'd say I'm more on the cynical end of the spectrum.
Well, regardless, I guess it is the way it is in the statute.
Brady, sorry, is this in line? I revised.
Yeah, I think that's fine
Okay.
from my perspective.
Jim, I think were you saying something? You're on mute.
We're basically approving attachment A.
To the memo.
Yeah. Oh, could you pull up the language of that we have right now, Ruben? Raul? You added free civil legal services in B after the strikeout.
So you got free civil legal services?
Yeah.
Can you make it bigger? Oh, sorry, I'm having a hard time seeing it.
Sure.
Or maybe just show the one doc.
How's that?
Selena, does this address most of the concerns? Like our discussion, like what we're gonna do and stuff?
It addresses everything I've heard. I would love to hear from, and I already emailed Earl about this. I think we need some of our community leaders who've been litigating for a long time to think about like what types of cases will come up. And I think that's largely to benefit future discussions on this issue. I really like the idea of a template that doesn't have to be used, but could help. I think, as the IOLTA community expands, a lot of the newer organizations have not gone through this kind of determination before.
And yeah, and I just want to emphasize, we talked a lot about LSC regulations, but our programs, that's only 11 of them, of the 100 and something. So the vast majority are not familiar with LSC regulations.
Will it be possible to have that template or checklist included as part of our package?
Yeah.
That might be ambitious. We can try though. The middle of June is the next rules commission meeting, because I think that template, Raul and Brady, that might be maybe that's the program side. After we have your chart, then maybe the program side staff can develop that checklist.
Okay.
But we will try. We'll see what we can do.
And Duan, when do you think this will go to the?
It would be great to take it in June. If you and Raul don't think that's enough time, then it'll be August.
Well, Raul, maybe in conjunction next week, you could get sort of questions out to Selena that we'd like her to circulate.
Yeah, I think also the momentum, because there are
Yeah.
programs that Selena just circulated the memo.
Right.
People that are already thinking about it right now. So I think this would be the time.
Yeah.
Yeah, that sounds good.
Okay, any other questions or comments, points of discussion, or should we move to the motion? Okay, doesn't look like anyone's hand is raised, so is anyone up for making the motion?
I'll make the
move.
motion.
I'll second.
I'm sorry, who moved? I'm
Jim,
sorry.
Jim
Oh.
moved, Will
Yep.
seconded.
Great. I'll do roll call. Al-Sarraf? Fightmaster?
Yes.
Blakemore, Bushelli,
Yes.
Campbell,
Yes.
Galkin, Meeker,
Yes.
Connolly,
Yes,
motion passes.
great. Thank you to Brady and Raul for putting this together and for all your work on this and for all your work that you're going to keep doing. We really appreciate it. It's a good way to get everybody kind of aligned in what they're supposed to be doing. So we really appreciate all the effort. And thank you for answering all of our questions today.
Honestly. Yeah.
Great. Okay, so now that we've finished that one, Will, let's turn to your point.
Sweet. If we have time, I have a brief presentation. Ready?
Yeah.
I'll go for it. Okay. Oh wait, I just messed up my presentation, of course. I'll start. First, I guess I'll thank Dewan and Erica for putting me on the agenda so I could make myself extra uncomfortable. I don't like having to share things, but I felt like this was important and an opportunity to kind of do a case study with some really smart people here. Let's see, I got it. See if I share the right one. And I had to do a slideshow because I don't know if it counts as a state bar presentation unless you have a slideshow.
We are seeing your speaker notes, so I'm not sure. You may want to just share.
That's probably the wrong one.
I think you need to just share your PowerPoint, not your whole screen, because your whole screen will show everything, but there should be a way to just highlight the PowerPoint.
Right? It's been a long time since I've had to do a presentation. So
Yeah.
I appreciate everybody bearing with me.
Oh, you're fine.
Please be
I've had
gentle.
to do a few virtual depots, so I have some experience with not sharing my whole screen and being like, here's my outline for all the questions.
Okay, let's try again. I have the slideshow up. I'm going to select this one. And
There we go.
Yeah, that's right. Great.
hey, everybody. So yeah, thank yous. My intention is to just share this as a case study, put my painful experience to good use. And I appreciate everybody sticking around to hear about this less than perfect kind of experience, travel, odyssey. But my hope is at the end, we can kind of have a discussion and maybe there's some ideas from all of the experts in the room, including staff, obviously, on what we might do to address from our position, to address some of the less than ideal circumstances I encountered. I'm not trying to call out any particular organizations, so I'm going to be vague in some of the details, but I want to try and go into it enough where it's helpful. So in February, I had a realization that I had a legal issue and that I was going to need some help. And so I started at the state self-help website, which was really helpful. It doesn't answer specific questions, but it was awesome for like explaining the process. That was very cool. But I know the importance of in-person assistance. Was going to have specific questions. So I decided I needed to go to court self-help. Unfortunately, they're only in town once a month. And so I had to wait. And this is probably a good time to mention some of the constraints, local constraints that afflict my situation. I am far away from services. It's a small town, about 5,000 people. The courthouse is open 3 hours a month in the town, and the nearest courthouse that's open daily is round trip 4.5-hour drive, and the nearest legal aid office open twice weekly is about 6-hour drive round trip. So it's far from the in-person resources, even though I really believe that that's the best way to try and get some legal help. So it's what we might call a legal aid desert here. We have 6 weed shops, 0 grocery stores, 0 dentists, and like a 1 midnight train. But I went in, and the self-help staff, after we had to wait, was excellent. They're really kind, but it was a lot. And I got, as I started to work through the paperwork, I got the sinking feeling in that 1/2-inch thick packet of papers she handed me that I was going to be way over my head. I was going to need help. So I went to the lawhelpca.org website, which just got a revision. It looks really beautiful now. Back then, back 2 months ago, it looked like it was from the 90s, which, nostalgia and all, but not ideal. But ultimately, it's just a big directory of providers. It's a list, and you can filter the list down to your area of law, but it doesn't tell you where to start. You get the list, and I know I don't need to start with the appellate services, but somebody else would be pretty clueless. So I took the list and got started, but it was an overwhelming starting point. Going there and feeling like, oh gosh, where do I go? Quick aside, I know that legal aid organizations can't help everybody. They have limited resources, but I still wanted to do my best to reach out and get the help if it was available. So the first agency I found, they had an online application, really excellent. I can fill it out on my own time. I submitted it. They gave me a confirmation page, 2 to 3 days. They will call me, and I better answer within 3 calls or they will give up and I need to reapply. It's not ideal, but I submitted it and I was on the wait. While I was waiting, I started to call. I wanted to call the next organization on the list. Called in at 10 a.m. And they had an automated system. I was 14th in the queue, and I'm like, okay, I can do that. And as I was waiting, I continued to search through their website to see what kind of services they provided and how it worked. And I discovered that they also had an online application to schedule an appointment for that day. So I filled it out, scheduled an appointment, and I was about to hang up on hold, and I was like, oh gosh, what if they don't call? Because I've had some poor experiences in the past where there's not the follow through. So I didn't hang up, I stayed on hold. I kind of went on about my day, listening to the saxophone solo on repeat, but the queue number kept going down. And after about 3 hours on hold, my appointment time came around, and unfortunately I did not get any call. There's nothing. But I had moved up in the line, so I was still hopeful that I was going to get to talk to somebody. But then 5 hours, I'm still on hold. And I'm feeling pretty bad. At that point, I wanted to just hang up, but I'm kind of desperate for some help. So I'm like, well, if I hang up, I might just call up and be on hold with somebody else. So I'm going to stay on hold. And 45 minutes after that, they answered. And I explained the issue, and they said, well, we'll check to see if there are any appointments available. And there were not. So 5 hours and 45 minutes to be told, no, we can't help you. But she did refer me to the first place that I had applied to already. And then kind of strangely to me, to the court departments. She gave me the phone numbers for the court departments. I didn't understand it, but at least it was something. And I was feeling pretty dumb after 5 hours and 45 minutes, but she said I could call back. And so I asked, well, is 5 hours a usual wait? And she said yes, but I could still call back and wait to get some assistance. It's like, okay, well, that's pretty defeating. But it's like, sorry. I didn't want to call back. I was feeling frustrated at that point and defeated. And I just felt like, it's okay to say no, but I would just prefer you to do it quickly. I did reach out to them in my personal capacity and say, hey, it would be great if you didn't make people wait on hold for so long. But they were responsive, and they apologized and said that they would address it. But I also felt bad for, those 10 people in front of me who also had to wait, because for me to have to wait that so long meant that there were other people really desperate for help and willing to sit on hold. So I expressed that, but I thought I would try a different organization, go back to, the other one in the county there. And they had a broken website. So I was kind of worried they had gone out of business. I called them during business hours, and they were like, please leave a message in our voicemail box. And then it went to the voicemail box, and it's like, the voicemail box you've reached is full, so you can't leave a message. So I was like, oh geez. But I called them back the next day, and they did answer. Wasn't a wait, but they only do in-person assistance. So if I could get the 215 miles to their clinic, I could get help. It's about 3.5 hours one way. I was a little defeating, and she tried to help out a little bit, but she just didn't know. So it was a positive in that it was a quick rejection, but left me a little more defeated. And then I tried the lawyer referral service, but of course you call them and you get the message, they're impacted by a staff shortage. They won't be able to call back for a couple of days. Please leave a message. And I did. They did eventually call me back, but after I'd already tried somebody else. And so I know you're probably getting the picture, right? Like it's frustrating, but I wanted to share this last part, because I think the quantity of obstacles matters, and it contributes to the poverty trap. In a totally unrelated example, I was trying to get some Medi-Cal help a couple days ago, and I had to give up after 7 phone calls where each person says, oh, you need to call these people. And they're like, well, I don't know why they told you to call us. We can't do anything about that. And it adds up. So I went back to the first organization I had submitted an application to on Monday. It was Thursday, and I called, and the phone wait wasn't too long, but she said the website was wrong. They didn't have a 2 to 3 day response time. It's 2 to 3 weeks, and I was going to have to wait. But I don't know if it's because I sounded sad, but she took pity on me, and she said, no, you know what? We'll have somebody call you back after 1:30, and they can do the eligibility intake and survey. And after everything that had come before, I cannot express to you how relieved I felt in that moment that, okay, finally I'm getting to the next step. Of course, they never called. They never called back. I think they called back the next week, and I missed a call, but they didn't leave a message or any callback information. It was just they disappeared. So then I went to the other organization where they were able to help and connect me with a couple of attorneys. I did get a call back, but I'm actually I'm still waiting. They starting in, I guess, really March, but I am still waiting. They said last week that they would be able to help me out last week, but then they got busy, and now they're supposed to call me this week. They have another day. We'll see. But at least they've been able to answer some of my more critical questions. And if they can't connect with me, I will go it alone, right? And I think that's what I want to emphasize, right? I don't believe that I'm entitled to assistance. They don't have to serve everybody. But I do believe that there's a important element of human dignity that comes up when you don't respond, or you make it really difficult to get past that first, just get in the door, right? Whether it's having to wait in a waiting room where they have the glass and they're like, oh, we can't tell you anything, you just have to wait. Or it's trying to get a hold of somebody on the phone when you're hundreds of miles away from their office. And if they had said, nope, you're on your own really quickly, it would have been upsetting. And I was still probably gone out and try and found an attorney who would take pity on me and help me out, or maybe hit up a neighboring county QSP. Or I would have said, okay, I'm just going to go it alone. But I've had enough bad experiences with state bureaucracies where going it alone on important legal issues is pretty scary. So I continued to try. So I said at the beginning, I wanted to share this experience as kind of a case study and then tap into the feedback from the experts in the room on, are there any ways we might be able to address the issues I encountered? Because it is really defeating. And I am on this commission. I work with people. I believe in this mission of legal aid. I cannot imagine how it feels for people who don't get clued into the system, don't understand how it works, and aren't feeling persistent, right? Like that they have to know that they have to keep pounding on the door if they want to get help, because otherwise they're not going to. And I think that's a less than ideal and ultimately harmful way of providing service. But we have an opportunity, right? Like my pain grants this opportunity to share this perspective with all of you and say, how can we do better? How can we encourage those folks who receive our grants to funnel people? Or how can we funnel people to the appropriate resources, right? Or communicate quickly that they're on their own, right? Sorry, you aren't going to get any help, but at least you know, and you're not left with this feeling of hopelessness that comes with just, are they going to help? I don't know. I hope maybe, I don't know. Maybe if I called these other people, and I can't, when I lived in Los Angeles, at least I could show up at the door, or I could go to the courthouse, or I could go to the clinic. And so you could be there face to face. But out here in the boonies, I had no idea the level of difficulty until I had to go through it. And I felt like it would be important to share that, get feedback, and maybe start the conversation and see if there's anything we can do to help just bridge that gap for folks who are far away or who don't know. And in so doing, kind of restore that feeling of human dignity and giving people hope. Ideally, right? We're not going to fix everything right now, but every little bit that you can move towards that goal, I think, is a worthwhile effort. And thank you to everyone who has listened to my story, and I appreciate it. Done. Scene. We're all over. Thanks, guys.
Yeah. So Will, thank you so much for being willing to share those that personal experience with us. Cause I do think it's hard sometimes for us to appreciate what that kind of on the ground, experience is. I mean, I've done clinics and tried to do some pro bono work but I've always been in an urban environment, and obviously it's really helpful to know, that there's this administrative time tax, right? That's sort of a big, issue of how people who don't have the resources, just their time becomes currency that they have to pay in order to get things that they're entitled to or to get help, right? So I really am grateful that you were willing to kind of share that with us. And I want to, I want to kind of think through what are different ways in which, because we are an oversight body, right? what are ways in which we can help with like that quality control problem, right? And, you know, obviously we want to be sympathetic to our organizations, given that, you know, there's funding issues and stuff with them, but like, what is it that we can do? And so I'm going to open it up to the rest of the rules committee, but, you know, I'm also sort of thinking about whether it's more specific questions in the discretionary grants, you know, like, do you have wait times, right? Like, what's your feedback, that kind of thing, where we can be a little bit more specific about some of these like potential pitfalls to kind of, you know, there's the whole adage, right? What gets measured gets managed, right? And so there may be a way to kind of push it in that direction, but that may not be enough. So I'm just sort of throwing out a couple of like, you know, some ideas of what we can do, but let me see. So Louise, you have your hand up.
Yeah, I'm not sure you're comfortable answering this question, Will, but I am curious as to what area of law you're having this problem in.
Family law.
Okay.
And it adds that emotional dynamic, which I did not realize how much that would gut punch me, but go on.
Well, the reason I was asking is because I think some areas of the law have a lot less services. Family law, however, as far as I'm concerned, has a lot of services. I was the family law facilitator in our county for a long period of time in Sonoma County, which is not a big county, not a small county. So I'm kind of horrified to hear your story because I know how hard it is. I worked with people like this, you know, and I worked for actually Legal Services Corporation many, many years ago. So now that I know what area you're in, I hope somebody has some ideas, because there definitely should be, like in our county, we deal with people outside our county by phone or Zoom or however we can. I mean, there's a way to communicate with people who live out, you know, out of the major metropolitan areas, and give them services via, you know, the internet and the, you know, whatever other resources are available. So I'm kind of befuddled and angry at what you've had to go through. But thank you for sharing that.
Thank you. I know there are resources out there. It's just, I haven't, you know, I found one and hopefully they'll respond, but the other ones, that's part of the battle, is finding.
So there's no, what county, do you mind saying what county you're in?
I prefer not on the record here. I don't want to call anybody out.
No, I understand. But I mean, there should be self-help access in every county in California. And maybe the Judicial Council is the place to find out, you know, who services your county.
She said, the self-help person who comes to town, she was very helpful, but she couldn't answer the specific questions and worries. And so then it's outside of that, well, I guess.
Was she an attorney or a paralegal? Do you know her status?
I don't. Yeah.
And then the county's all very, in the county I worked in, we were not supposed to give legal advice. Well, how do you define legal advice? You know, and I always defined it as something I would not tell the person if the other person was sitting in the room. That would be more like, you know, strategy. But a lot of legal information, you know, like what the law says and stuff like that, can be disseminated, but a lot of people have rules that you can't do that. And then you may be running into that roadblock too. So sorry, I really feel bad for you.
Thanks, Louise. Dwan and then Vanetta.
Yeah, you know, one idea I had, and I did share this with Will already recently, was, you know, at least in the purview of the Rules Committee, there is a topic that by design, that's a little bit of a catch-all topic that we're saving towards for next year when we're kind of winding down the Rules Committee work, that's grants administration. And what we're imagining in that is kind of like, Erica, you're working on the fiscal compliance piece, but then the program compliance piece. And there is a guidance. It's not a checklist that we use when we go on monitoring visits, but there is guidance, right, for what the staff can inquire about. The commission is welcome to, or the rules committee is welcome as part of that topic to look at that guidance piece and see if we want to add things to it. We do have to actually think about our monitoring visit at some point in the next year or two, because the way our monitoring visit was designed previously was really just to get at IELTS and EF funding. We've now, because of all the additional streams of funding that we tack on. So say they get a bank grant, we do like one another like an interview with a bank grant like staff. If they get HP, we do one, but we definitely should run by the commission and EBR and all the various sub entities and see actually how you want to do that monitoring for the program side. It's become very fiscally heavy. And then because of all the grants, do we need to start moving to like a 2-day visit? Or do we want to stay with the one? We used to all do it like in person. The pandemic, we've done it remotely. So I think we want to actually move to a hybrid model where the programs that need a little bit more heavy monitoring, then we go in person. Otherwise, say you haven't had a finding and maybe 2 visits or whatever that barometer is, maybe we keep it as a remote. So we do need to customize it a little bit. And that is something that I think would be part of the grants administration. And then part of this is maybe this client satisfaction wait time issue. And then if we can then pass that information along, Eric, I really like the idea about in the discretionary grant realm, because, you know, IELTS and EF, the way it's designed, I agree with this, right? Stable funding. We're not trying to, we want to give programs some assurance that they're going to get it. And plus we don't have a statutory authority, right? Programs eligible, they just get it. But I think in the discretionary grant, it's competitive, right? So if you are not providing, it's a customer service based delivery service. So if you're not meeting those, then maybe you should not get additional grant funding from us in terms of discretionary grants. But so that's something I think we could do in terms of like as a rules committee. And that's my thoughts.
Yeah. Thanks, Dwan. Vanetta? Oh, Vanetta, sorry, you're still on mute. I just want to catch you before.
Hopefully not too much noise, but I think I can still at least resonate with that component of we're talking about major systems issues, right? And difficulties in navigating these systems, and organizations have responsibility to, as you're saying, customer service. If they have the proper infrastructure and training and logistical, the bandwidth, then they can navigate this themselves. But my thought is that they may not have that bandwidth because they're just trying to function, but not assessing the quality of their services. And so in terms of the role that perhaps we can play is looking at asking questions around the logistical infrastructure, their capabilities, kind of strengths and growth areas, and try to factor that into additional training or support. The other part is you were talking about, we're talking about working with indigent clients, and they're already feeling very vulnerable that they don't have a voice, and they may not be able to wait 1 hour. They may not have the resources to do that. And so I think that your story it's really abominable, but it speaks to service delivery as part of getting access. And that's one thing that seems to be lacking. So.
Vanetta, you kind of cut off on the last part, but I think we hopefully got the point, which I think is a really good one, about kind of focusing on organizations' infrastructure and their ability to deal with this. And obviously also the rural component is quite big too. I know when we did I did some discretionary grant, there were, suggestions of satellite, visits, and maybe we need to like emphasize that more, right? Or provide more points if they're higher, if there's more frequency or something. Anyway, Jim, and then Selena.
Yeah, I was just going to say, well, the Access to Justice Commission first addressed the problems of rural access back in 2010. Its report, it was about 3 years to write that report. And
good report.
There were 2 major purposes. One is to define the problems of rural access, and 2, to come up with a non-arbitrary quantitative way to define rural areas, since we have very large counties in this state which have urban as well as rural areas like San Bernardino. And we also put an explicit plea at the time. I was not on the Legal Services Trust Fund Commission in 2010, but we put a specific request to this commission about trying to fund more rural access. And through the years, and I know through the lobbying with Selena and LAC, they've been successful at getting rural components in some of the discretionary grants, in particular the homeless prevention grants. I think homeless prevention grants 2, 3, and 4, all the competitive grants all had a rural element in it, so that those agencies that were writing these discretionary grants that had a rural component were rated higher. Now, your experience just goes to show it hasn't solved the problem. The problem is still there. And it also shows it took like a 10-year effort to start getting money allocated on the basis of rural issues. And also, when we were discussing, I guess it was 2 years ago, on the eligibility issues and on the funding formula, whether or not to use 125% or the 200% of the poor, this commission did the analysis to show that if you use a 200% eligibility level for defining the clients for the funding formula, that would significantly shift money from the rural areas to the urban areas. And so that the legislation then was changed so that clients' eligibility was based on the 200%, but the funding formula was based on the 125, specifically to preserve more funding for rural areas. So there have been efforts. Obviously, there needs to be more.
Thanks, Jim. That's really good context. Yeah, everything's so slow moving when you're dealing with like the legal world at times, right? We're trying our best though. But I appreciate you bringing this up because I think there are ways that we can get creative to try to address the issue. Go ahead, Selena.
Well, I'm just really sorry that this has happened to you. Like every time you interact with a corporation and you're put on hold, you just feel like they don't care about you as an individual, as a human being. And it's frustrating when our legal aid community unintentionally communicates that message. So like a 5-hour hold time, 5 hours and 40 minutes, that seems completely ridiculous. And I feel like there's a piece here that like erodes public trust in legal aid generally. If you didn't, you were the person who is persevering, who is like trying multiple options, who goes to law help, which does work better now, and like tries all these methods to get actual legal help. And most people, I think, would give up before that. They would try a couple different numbers, they go to a couple websites and they give up. And so the next time anyone in their community asks for help, they'd say, oh, don't go to legal aid, they don't help. And so that's a piece that like your individual experience is really demonstrating what is a bigger problem, that the communities won't trust legal aid and won't go to legal aid, even if it's an issue that legal aid is the perfect solution, because it's an eviction notice and legal aid's fast on that, because there's like complete lack of trust in responding. But on the issue of family law, I think the family law facilitators are actually still probably the best service providers right now because they're in every county. And they do provide a lot of really great legal information, but it's really hard when they're only open 3 hours a month. And that's a court funding issue and why we always try to get more court funding. But I'm sorry, it is not fair, and it is not what we would want anyone in legal crisis to face.
Can I add one more thing?
Yeah, please, of course.
If you go to the Judicial Council website, there is an awful lot of information about forms, how to fill them out, where to get help, your rights. So I just thought I'd throw that out for you too. I don't know if you've been on there.
Yeah, I think it's great. It's an excellent resource. I think what I, didn't expect is how I have a really hard time thinking clearly on this matter, and I run into like, how should I don't even know how I should ask this. And I just didn't expect that part, right? Where it would be so challenging. Whereas like when I had to deal with the UD issue, it's emotional, it's fraught, but I'm like, oh, we got to get it done, gung ho, we're going all the way. And it felt a little easier in some ways than this sort of thing. And I guess I'll respond briefly to a couple remarks because I really appreciate the remarks, and I can't imagine folks who have it worse than I do. You know, I can persevere because I know that there's this group that's working really hard, and I feel like everybody I spoke to cared. They were just doing the best they could in a bad situation. Even the person who was like, hey, is it normal to wait 5 hours and 45 minutes? You know, obviously she's trying to get through her day just like I am, and they're doing their best. And so Vanetta, when you said maybe they just don't have the infrastructure to implement good systems, I think that really resonates with me. Like, how do we empower them? Is it the monitoring visit, or is it we ask them to say, how many calls are you getting a month? Because one thing like the client satisfaction surveys will never catch is the people who give up. Because I will tell you, if the current QLSP actually ends up helping me get all this documentation done, they're getting 5s. Everything was great, because I will be so grateful that they could help me. But it's the people who give up, who can't get through on the phone, or who never get a call back. And because they're just, they have that piling on of like, everybody needs help, they can't get back to them. And so maybe it's just, how many calls are you getting? How many can you respond to? And that, not even to penalize them, but to get a better sense of what the need is. And there's also a financial advantage if the first group, you know, if they're not having to call everybody, because that's one less phone call you have to answer, one less application you have to. But right now, it's the shotgun approach. You got to call everybody up and hit up everybody, hoping that one of them says yes. So, and I did read part of that report, Jim, and it was really great. It was helpful in understanding the difference between rural, urban, and I think it's great. And some of the suggestions in there are recommendations. I'm like, oh gosh, how do we keep moving forward on those? Because there are folks who don't have this access. So however I don't know what the next step is. Waiting a year, it would be disappointing to me. I don't know if we can have a further conversation, or if I can work with staff, or I don't know what happens next.
Yeah, so Will, actually, this is a good question. I guess one of my questions back to you is like, what would you like to see us do? Like, what are some of the things that you think we can do to, you know, you've been on the commission for a few years now. We've been sort of throwing out random ideas, but I'm curious if you have like some proposals that you would like us to work through and try to consider. If not, that's fine. I just wanted to make sure I gave you that opportunity.
On the client side, like how I feel it should work, sure. I have ideas, like don't make people wait a long time. Very quickly say no. Warm referrals are the golden standard, right? Like that's easy, but what I wanted to lean on this group for was like, how would we collaborate with legal aid organizations to encourage that outcome, those outcomes, right? I don't know. I don't have any ideas really on that, other than, well, we can increase reporting in some areas. Maybe we can do some creative reporting, especially on the discretionary grants where we get to set the rules. That might be a great area. I don't know exactly where our jurisdiction, what kind of, you know, is this a professional standard that legal organizations should meet? I don't know. But that's where I wanted to lean on this group, because if there are, and could start the conversation, because if maybe you guys have the answers and I just have the experience and say, well, will that result in shorter wait times, or will that result in quicker answers, or even just who should I call first is overwhelming. When I get 7 organizations on the legal help website, it's like, which one do I start with? Do I start with all of them? Okay. Like that step-by-step could be helpful.
Got it. So I feel like it sounds like there's a couple of different issues that we could kind of highlight and focus on. One is, I think, an outreach and like publicity element, right? And, you know, obviously we have, as an organization, we mainly just hold the purse strings and then sort of regulate on the purse strings, which is very powerful, but we're not like, at least I'll confirm with Dwan, but we're not like the bar where we can do necessarily like a professional responsibility type of regulation. Dwan, am I correct on that?
Well, the state bar regulates attorneys, but the purview of the commission doesn't regulate, like, I mean, you're regulating, I guess, in a way, like the organization through this codification process and all the rules, and but if it's a professional like responsibility rule or something like the model rules of that goes to a different office, and at the state bar, the Office of Professional Conduct.
Okay, I guess more generally. Oh, sorry. Go ahead, Louise. Oh, you're still on mute. Sorry.
Since Bonnie House retired, we do have a representative from the Judicial Council, correct?
Dawn,
I
you're
don't know
on.
if Melanie's still on. Melanie and Laura are the Judicial Council liaisons.
Because that's it's an avenue for discussion. I mean, I do know Melanie. I've known her forever, but because that's a road into that access, funding, that kind of thing from their perspective.
Yeah.
I mean, as far as setting best practices for their, or even like minimum thresholds for their, like the organization's, conduct, for lack of a better term, do we have that authority? I want to sort of ping Dawn and Brady on that. Is that something that we have that ability to, I'm with you, Will. I don't want to penalize people, but like to try to like get,
Right.
you know, get some of these issues like at least out in the
All right,
open.
I don't understand the question. The authority for what exactly? Sorry.
Well, so it's clear that, you know, we have authority to kind of evaluate their fiscal, you know, situations, right? And like determine that they're using the money in an appropriate way. You had pointed out that in the monitoring visits, there's a sort of other angle, which is like their operations, I guess.
Yeah, well, I think you could fit in our internal controls, which is a statutory requirement.
Oh.
They have to have, I can't remember what the phrasing is, like satisfactory internal controls, reasonable, there's something attached to that.
Quality control procedures, I think.
Quality there, exactly.
And we use the
Okay.
APA
Quality internal
standard.
controls. And
which
so
I
that's
believe
how we
speaks
get
to-
all the monitoring visit stuff. And then there's state bar rule that says like, they need to, what we use for monitoring is the ABA standards of ABA model standards rules. I'm paraphrasing kind of a thing. So presumably you could have another rule that references either something else, or you guys create another rule that gives additional guidance in terms of like conduct. But that's, yeah, that's the codification process though.
Okay.
Yeah.
I mean, that sounds like one way that we could, and I know, Will, this isn't very satisfactory, that it may take a while to kind of like run this
Well,
through.
I'm not expecting a solution today.
No,
for
no,
sure.
but I think sort of when we get into that particular rule, like I think keeping this in mind would be really helpful. The other thing I was thinking is, I know, and I think, Will, you were on this working group about the complaints procedures and that kind of stuff. And, you know, I don't know what the status of complaints has been, but, you know, and I'm not necessarily, but if there's a way in which, whether it's through complaints or through surveys, we could get more information about, you know, how prevalent this kind of a problem is, whether that's, and I'm not sure if that's something we can do sort of through our rules or officially, or, you know, if there's a way, but that might be, to your point, like, if we're not capturing what's sort of happening, we don't even know how to fix that problem, right? You know, your story is very helpful in giving us a window into it, but like, it's also helpful to know, is it like anecdata, or is it like, this is statistically an overwhelming experience for people, and in where, right? Is it, you know, are all the urban folks able to get in and the rural or not? And so that can help us kind of with addressing it. It sounds like the Access Commission's done some really great work on this, so I don't want to double up on them, but that would be a really, I think, important way to get at it, is to have some way in which we can let people come tell us so that we know, right, what's happening. But I don't know, Selena, do you, or Vanetta, your hand's up, and then I would love to hear if Selena has views on this. I don't want to overburden everybody. either.
Yeah.
Go ahead, Vanessa.
No, I was just gonna say, the first thing that comes up is if the organization did a needs assessment. That's really what we're talking about, right? You know, a needs assessment of their
Yes.
structure, their functions and so
Great
forth.
point.
And that's a way of building, it's kind of like having a training emphasis as opposed to one being punitive,
Yes.
because if they can look at their own limitations and they can come up with ideas as well.
Yeah, I think that's a great point. Like keeping the focus on helping to like build the infrastructure for these organizations rather than being like, well, we're just going to starve you until you get better, right? Like that isn't helpful.
At least start there.
Yeah. Duan, go ahead.
Yeah, so one thing we want to do is something more quicker, but that's not like a requirement. But we are at the suggestion of this, I think it's this committee or another committee, the state bar staff is doing like a training around some of the compliance issues that have like surfaced to monitoring visit. One thing we can add a couple slides just saying like, don't forget about like client satisfaction. You might want to do a needs assessment. These are things you might want to do without going into codification and getting commission approval.
Yes.
We can't really require at this point, but we can say these are things that you would want to consider. And the commission is going to be looking at this more closely in codification. If in the meantime, if you need technical assistance, please either come to us or come to LAC for like more of the one-on-one.
Thanks, Duan. Those are great ideas. Selena, go ahead.
I mean, I was just going to basically say the same thing as I think the state bar staff can do really great technical assistance on this issue. Even popping up a standalone, sorry, everybody's moving, even popping up I'm trying to look at you, Erica, even popping up like a standalone, like Zoom about best practices in client intake online and by phone. There has been a lot of attention in the national legal services world on intake, and Equal Justice Conference is next week. A lot of organizations are presenting on intake, and there's a lot of attention also on like client feedback via text, but that assumes that they got through the door and got representation. And I know there's a lot of organizations that have really great hotlines that do track things like their hold time. And some of those organizations could present in an informal, state bar TA around, here are organizations who figured it out. And I think it's important for our community to hear, like, this is all about community trust. It's not, is your wait time 20 minutes versus 19 minutes? It's what does the community believe about you because of your responsiveness? And I can't remember who it was, but somebody was saying years ago that like, this may have been in the context of the Justice Gap study when we were designing it. So maybe it was Jim, but talking about if someone doesn't go to legal aid, then we don't know that we haven't served them because they don't go to legal aid. So they don't get in the intake system. They don't even get on the call, but because it's like an upstream problem. And I don't know if how hard it will be to measure that except for through the Justice Gap study, but organizations should have a sense of how long people are waiting on hold. That feels like a data point.
Yeah. And maybe how many hangups.
Yeah. I've you inspired a few ideas there, because a lot of new telephone systems, they track that, right? And it would be really easy for them to pull that report. And just by pulling the report, maybe they realize that there's a problem, and we can encourage change that way. Other things that came up was, out of date websites. The one organization I went to that hadn't been updated since 2021, and their website had broken links and all of that. And I was like, I went into Smart Simple to make sure we hadn't stopped funding them, because I was like, well, I don't want to waste my time if they're defunct, but we were. And I was like, okay. And also remote services for rural people, like either text or Frontier. I've learned a new term, Frontier, based on that report that Jim was talking about, the MSSA, Frontier, Rural, Urban. And, if they don't provide remote services and I know I'm 200 miles away from them, well, I don't want to, if we could clarify that and make it its own distinction, that helps in me not wasting my time and also not wasting their time, because all they're doing is saying, oh, we can't help you. Just like on that long wait time, if they had somebody who could answer the phone and say, oh, we can't help you in that area, well, please call back on Thursday, right? Even that, it helps build the trust. and makes you feel like a human being, right? Those sorts of things that you really have to think about. And I don't know how to encourage those things, but there are small things that really matter when you're trying to get some help.
Yeah, absolutely.
Thank you.
Jim and then Selena. Jim, you're still on mute. Sorry.
I was just going to ask Selena, do you know if they're planning on doing another justice gap study? And if they are they going to specifically look at rural versus urban areas?
I should probably answer that, Selena, because it's not Selena that does justice gap study, Jim, it's the state bar staff, and Erica is actually the point person on it, if you want a brief update on that.
So they are doing another one?
Well, they as in us, yes, us.
You guys are, okay.
Yes.
But is the rural issue going to be specifically addressed? Are they going to sample rural areas?
Erica, do you want to take that?
Sure. We're kind of still in the initial planning stages, so we're gathering kind of our ideas about what needs to be covered in the next iteration, but we haven't made any final decisions yet. So that is one of the topics that we're considering including, but it's obviously going to be subject to kind of whatever restraints we might have on all the topics that we can cover within a limited amount of time. So it's on the table.
Okay.
Thank you. Selena?
I was actually curious, are any state bar staff going to Equal Justice Conference next week?
We can't because it's in Texas. We're prohibited from
Oh,
going.
yeah, sorry. Well, I'm going. It's my home state, and I'm going to see my mom while I'm there. But there are 2 sessions that actually look really good. I will send, Dwan, I'll send you the link to those 2 sessions, because one of them is Legal Services Alabama, and the other one is Legal Aid Services of Northeastern Minnesota. And they both looked at all of their intake systems with a client-centered model of looking to see, in person, online, and phone, to figure out how they could be more welcoming in particular. So I'll send you the links to those.
Okay.
Maybe
I can send it out.
Yeah, maybe even asking like how if their state bar is involved might be helpful.
Thank you, Selena.
Great. Awesome. Well, it sounds like we have at least some, kind of initial thoughts and ideas, doing, the presentation and adding kind of customer service as a talking point with the LSOs, adding this to the rules committee topic on monitoring visits for next year. I think your point about kind of the small fixes is small. I say small, but it may not actually be small for the organization, but like keeping your stuff up to date, maybe posting like who's available on what schedule, right? And sort of sticking to that, or having ongoing updates online that say like our person's out today, so don't call, right? Or they're not coming in until Thursday, right? Something that's a little bit, basically, sort of someone who's responsible for kind of updating real time. Those may be good, suggestions that we can like encourage based on the feedback here. And then longer term, we can kind of try to build these into, actual like standards for monitoring and thinking about how we can get information from the communities that we're trying to serve, so that we're also hearing from them, not just the organizations, right?
Yeah, I think those are excellent things. And if you or Dewan have suggestions on how I can help contribute or push that forward, I'm glad to give suggestions and point out areas where it might be worth exploring, or even Selena, I guess, because you have the website, the main portal. I'm glad. Yeah, just tell me what I should do, and I will do my best. Obviously, there are other things going on, but I will do my best.
Awesome. Okay, well, let's definitely put together kind of some like thoughts on this, and we'll try to keep in the short term, if you could kind of keep this as your sort of space, and like make sure as we're moving forward, you're kind of like, hey, that meeting, did we kind of come up with that? That would probably be helpful. I'll try to remember as well, just to like check in. But that would be, I think, in the short term.
And just to clarify, that training that we're having, it's not going to happen probably until later this year. So just to manage everybody's expectation, it's not going to be in like the next month or two. So it'll be
no
later.
problem.
Okay.
But
you.
even more reason to, make sure we'll try to remember to keep that on forefront there. And yeah, thank you, Will, so much for sharing that. I think it's something we don't get that perspective often enough. And I'm really grateful that you were willing to share that with us to help us be better as an organization and to try to address, I think we're all here with the goal of helping people get access to legal services, because when you get involved with the law, it's really scary. It's really scary for me, and I'm a lawyer, and I'm like, so I really, really appreciate you bringing this forward, ask and taking the time to share this with us. And we, we'll do our best to try to back you up on making some of these improvements.
I really appreciate that. And I really appreciate everybody who listened and gave feedback. I hope it doesn't end here. Obviously, I know that that's how we're limited in how we can move forward. But I'm so ready and willing on this one, especially for the small things where they might be able to make small adjustments and just highlight it for awareness' sake. Because my experience is, as soon as folks know, they want to do better and they want to address it. But sometimes they don't even realize that they've created this filter because they're just so overwhelmed.
Yeah.
So I really appreciate the time to everybody. And I'm glad to be a resource. Feel free to email me or call me or text me, whatever, and I will chime in if I can and help out.
Awesome.
Thank you.
Okay. Well, with that and our sort of task going forward with some ideas on how to try to address this issue, are there any other things that we should raise before we adjourn for the day? Okay, hearing none, I assume we can move to adjourn, and we'll see you all, I guess, I don't know if it's next month or whatever. I haven't looked at my calendar, but in the meantime, we'll work on, brainstorming some additional ideas to address your stuff, Will. And you're always welcome to reach out to me. We can have a call if you have come up with other stuff you want to talk about.
June is the next meeting. It's before the commission. That week of the commission meeting is also, there's a rules committee meeting.
Okay, perfect. We'll see you then. Thank you again to Brady and Raul for their work on the rule. And we really appreciate it. And we'll see you all in June. Have a great one. Have a good Memorial Day weekend, our next holiday before. Bye, everyone.
Thanks, everyone. Bye-bye.